This is from justiceforsurvivors.ca. Damages for Pain and Suffering, September 27th, 2019, by Elizabeth Grace. Concluding the sexual abuse and its impacts, we're at the upper end of the worst-case scale. An Ontario court has awarded a plaintiff 400,000 Canadian dollars for non-pecuniary damages. DS versus Quesnel, 2019, ONSC 3230. From ages 5 to 10, the plaintiff had endured horrendous weekly assaults by his stepfather. In making this award for pain and suffering, the court expressly chose not to be restricted by the cap on non-pecuniary damages that the Supreme Court of Canada, in its 1978 trilogy of decisions, said should apply in catastrophic personal injury cases. This cap was set at $100,000 in 1978, but adjusted for inflation, it amounts to $368,000 in 2019 dollars. It has long been recognized that the policy reasons for a cap in catastrophic personal injury cases that result from accidents and negligent conduct simply do not apply to intentional misconduct, like assault, which is a distinctive wrong that causes unique harms and injuries. Unlike other unlawful conduct, assault is a targeted and inherently violent form of abuse of power that humiliates, degrades, and violates the dignity of those who experience it. Notwithstanding its decision to introduce a cap into Canadian law, the Supreme Court of Canada has accepted that there are circumstances in which it will not apply. For example, in the defamation context, there is no arbitrary limit on what a person who has suffered damages to reputation and dignity may be awarded as non-pecuniary damages. Hill v. Scientology of Toronto, 1995, 2 S's in Sierra, C as in Charlie, R as in Romeo, 1130. In 1976, the British Columbia Court of Appeal extended the exception to a case of incest by a father against his daughter, finding the policy justifications for the cap simply did not apply. S as in Sierra, F as in Frank versus FGC, 1996, Can L2 6597 BCCA. Unlike with catastrophic personal injury, there is little risk that a plaintiff who has been assaulted and suffered devastating psychological harms as a result will be overcompensated because of already generous awards under pecuniary heads of damage, such as loss of earning capacity or cost of care, that are intended to provide lifetime economic security. Nor are awards in assault cases ones that could negatively impact the public purse or cause enormous increases for insurance premiums, both concerns that inform the Supreme Court of Canada's decision to introduce a cap on non-pecuniary damages for personal injury. And yet it took more than 2 decades, for an Ontario court to address the appropriateness of the cap. Of course it did. In the sexual abuse context, with the release of the decision in DS versus Kensnell, we now have in Ontario an unequivocal statement that the cap should not constrain damages for pain and suffering for abuse, and an award that actually exceeds the amount of the cap. This is consistent with the trend towards greater recognition by society and by our courts of the depth of the harms caused by sexual violation and exploitation. While the claim in Diaz versus Kesnell was undefended, the court's decision should help pave the way for awards that reflect the full extent of the wrongs perpetrated and their consequences on individual survivors of S abuse. Courts need not feel artificially constrained by precedents that have either explicitly or implicitly been informed by the CAP or by the CAP itself. Contact Elizabeth today. Learners understands you need someone to believe in you. Our consultations are free. Free, troll. Call today and let us help you and your family. Call 416-601-2378 or email egrace@learners.ca. Thank you. I will leave a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night wherever you are. Peace.